Mr. Attorney General, one of the reasons we have a crisis at our border where we have illegal aliens running to our Border Patrol, not away from our Border Patrol, is this interpretation of asylum, that anyone, anywhere who lives in a dangerous or poor country can come here and seek asylum, as opposed to seeking it, as is traditionally the case for things like persecution on religious belief or political practice. But let's move on, Mr. Attorney General.
But that's not the standard. I want to be clear.
I want to come back to a question that Senator Cornyn started. Your unprecedented memo in December of 2020 to direct your prosecutors not to pursue the most serious, readily provable offense. I have gotten numerous contacts in my office from your prosecutors who are shocked that you have overturned this decades-long bipartisan standard. You said this was about allocating resources. What resources are you talking about?
No prosecutor was directed to not bring a case again. In fact,
your memo specifically says that if they feel that it's not warranted, or only if the other offenses are not sufficient, they should not pursue what has been the standard for decades, generations of U.S. attorneys and their assistants.
I'm well aware of the standard because I helped write the standard originally.
Because it was a Carter administration standard, not
right.
Specifically known for being tough on crime.
Well, it was the first time the principles of prosecution were reduced to a book which explained what they were. It was included in it. Every assistant U.S. attorney is able to use their discretion to bring these kinds of cases. No one's being directed to not do anything.
You specifically said that they should not pursue the most serious, readily provable offenses in cases where mandatory minimums are present because it's not warranted. You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice not to pursue it if we write the law in that way?
The memorandum said that cases of violent crime, which is specifically what you're asking me, are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimums.
Is it your assertion here that drug trafficking is not a violent crime?
No,
it's built on an entire foundation and edifice of violence.
Yes, and it includes an exception in the same memorandum we're talking about for significant drug trafficking as well as for violent crime. That's right.
Let's get your specific answer. I wrote it down here. I was so surprised by it. You said to Senator Cornyn, this is about allocating resources. Yeah. What resources are we allocating? If one of your assistant U.S. attorneys has some criminal lowlife who could be charged with 12 offenses, but they don't charge the two most serious readily provable offenses because of your memorandum. They're still charged with 10 offenses. They have to go to a grand jury. They have to go to trial. They have to have a pre-sentencing report. They have to have a sentencing hearing. How is that conserving resources that you don't charge them with the most serious readily provable offenses that would lock these lowlifes up for the longest time possible?
Lowlifes that you're worried about and have expressed worried about, the large drug traffickers, the violent criminals, they are to be charged to the max.
I ask again, what resources were you talking about? You said to Senator Cornyn specifically it was about allocating resources. What resources?
These include our investigators and how much we have to investigate in order to establish the requirements for mandatory minimums. The prosecutors have to prove those cases, the judges who have to try those cases, and the jails that have to hold those cases, those individuals for longer terms.
Jails are, I don't see how jails could be a problem. You only have 158,000 prisoners now. 10 years ago, it was 219,000. Do you need more prisons?
Well, I think that...
Kenny's an appropriator. I bet he could get you more prisons.
I think many of the senators have complained that the jails are too filled, that they're overcrowded, that we're not able to provide the level of protection and security for guards and for prisoners that we would like. But that is not what this is about. Again, I want to be clear. The memorandum was crystal clear that they are to charge the most serious provable offense in cases involving violent crime and drug trafficking.
Okay, let's turn to another example of you overriding Congress's will. Congress has repeatedly decided to impose stiffer penalties for crack cocaine than powder cocaine, done originally at the request of members of the Congressional Black Caucus, voted for by senators like Senator Durbin, the chairman of this committee. 10 years ago, they made change to that. They specifically kept the ratio higher, and they didn't make it retroactive. Now, you have directed your prosecutors, when they are dealing with crack cocaine, to charge it as if it was powder cocaine, something that this Congress has repeatedly refused to do, which we refused to do as recently as December when Senator Booker tried it on the floor and I blocked it. How do you explain overriding Congress's decision on this distinction between crack and powder cocaine to suit your own policy preferences?
The long-standing rule is that the Department of Justice uses its discretion in which charges to bring, regardless of which ones are available, which ones are to bring. Every bit of evidence we have is that there's no difference between powder and crack. Governor Hutchinson testified to that fact.
Those are legislative decisions. Those are not prosecutorial decisions. If this Congress wants to do it, maybe it will one day, and maybe I'll be outvoted. But those are legislative decisions. Those are not prosecutorial decisions. You said at your confirmation hearing that you had to follow the law as it was written, that the executive branch could not rewrite the law. What you were doing is rewriting the law. It's not a single prosecutor out on the front lines making one decision. You're directing every federal prosecutor to override the law that has been written by Congress.
We're using our discretion as to which charges to bring, in which circumstances, which ones are appropriate. That's what we're doing. That's a long-standing history of prosecutorial discretion in the United States.